Hi, Sadia. I think you're muted.
Thank you. Sorry. Good evening, everyone. It is currently 7:05 p.m. in Sri Lanka. And for those of you joining from other parts of the world, good morning, very early morning or afternoon. I, Sadia Ria, will be your host for tonight. And it is with privilege that I warmly welcome you to IIMC Colombo's second event, the panel discussion on investor-state dispute settlement, framework, practice, and capacity building. IIMC Colombo is organized by the Moot Court Bench and made possible by our IIMC partners. I extend my gratitude to our supporting organizations, the Ministry of Justice, Sri Lanka, and Sir Charles Regional Center for the Asia and Pacific, the International Mediation Institute, together with the Young Mediators Initiative. Our silver sponsor, Changarot Chambers LLC, and our bronze sponsor, ODR Asia at Changarot International Consultancy. Our education partner, Mediator Academy, skills development partner, Sage Mediation, institutional partner, the Consensus Group, and our official research partner, Jasmundi. Finally, our career partner, the World Association of PPP Units and Professionals. Today's panel will be moderated by Amra Minza, an LLB undergraduate from Staffordshire University, UK. She is currently following the mediation accreditation program at IIM campus and represented our university at the 16th ICC Paris Mediation Competition, where she secured Best Acknowledgement of Cultural Differences, and her team ranked 10th out of 48 teams. Similarly, her team ranked 4th out of 22 teams at the 6th Bucerius Law School Mediation Competition in 2020. Amra has also coached teams for the Mediation National Rounds in Sri Lanka and IMSG 2021. At the MCB, Amra was the head of instructions and communications, and she has also been the secretary of the MDMMS Society at Apit Law School, Sri Lanka. She was also in the organizing committee of ALSYNC 2021, and as evident by her impressive achievements, she has a fierce passion for mediation and ADR. About today's panel, we will have a session which will be followed by a 10-minute Q&A at the end of today's discussion. And I encourage all our participants to share your questions with me in the chat box, which I will then direct to Amra. With that being said, Amra, the floor is yours.
Thank you, Sadia, and welcome once again to all of our esteemed panelists and audience present here today with us at the IIMC panel discussion on a very interesting topic and an emerging topic presently on investor-state mediation, framework, practice, and capacity building with our leading experts to share their insights. We have Frauke Nitschke, a senior counsel at the International Center for Settlement Investment Dispute, ICSID, as we all refer to commonly. Frauke serves as the team lead for ICSID staff handling proceedings in English. Frauke has also served as Secretary Tribunals, Conciliation Commission, and ad hoc committees in investor-state proceedings, conducted pursuant to the ICSID Convention and the ICSID additional facility rules involving a variety of economic sectors and legal instruments. Frauke leads ICSID's investor-state mediation activities, including the drafting of the proposed mediation rules and the amendments to the ICSID's conciliation frameworks. Frauke has conducted investment mediation skills training for mediators and government officials. Prior to joining ICSID, Frauke served in the World Bank's legal vice presidency and the inspection panel. Frauke is an accredited mediator and admitted to the DC and New York State Bar. She holds a law degree from Free Universität Berlin and an LLM from Georgetown University Law Center and a master's degree in psychology from the Fernuniversität Hagen. Welcome, Frauke. Pleased to have you with us today. Moving on to, we have Alejandro Carvalho Leda, LLB with Economics and LLM, European PhD in International Law, Harvard Program on Negotiation, CEDAR accredited mediator, and is a general counsel of the International Energy Charter and heads its Conflict Resolution Center, which provides good officers and mediation support. From December 2020 to mid-September 2021, He was also the acting Deputy General, Secretary General. He coordinated the Guide on Investment Mediation 2016, the Model Instrument on Management of Investment Disputes 2018, and the first training investment mediators. Currently, he supports several countries in developing their internal instrument on prevailing managing investment disputes and is working on a joint research paper with the World Bank on investment dispute prevention in the energy sector. Alejandro also teaches foreign investment law at Paris Pantheon Sorbonne. Welcome, Alejandro, and pleased once again to have you here with us today. Moving on, we have James South, who's the Chief Executive of the CEDAR, and as a facilitator, mediator, consultant, and trainer. James has over 25 years of experience in over 30 countries, working with individuals, organizations, and public institutions to prevent, manage, and resolve conflicts effectively. A lawyer in his native, which is New Zealand, he acts as a mediator both in the UK and internationally, specializing in corporate and commercial disputes with particular experience in international commercial contracts, insurance and finance, property, sales, and I can go on with his expertise. James also combines his mediating and consultancy skills to provide facilitation, mutual sharing, and conflict coaching services to boards, leadership teams, and other groups to which finds themselves in conflict. James is also a fluent in a Spanish speaker and trains in cross-cultural issues in mediation, and has experience in mediating cross-border and cross-cultural disputes. In the recent years, James has been working on developing areas such as board and leadership level within organizations and in investor-state disputes, working with ICSID and the Energy Charter Secretariat to develop and deliver specialist training for mediators in investor-state disputes in Washington, Paris, and Hong Kong. Moving on to Wolf. Wolf von Kumberg was over 25 years the Assistant General Counsel, International for Northrop Grumman Corporation. The company has an extensive international presence and invested in projects in over 52 countries, often in joint ventures with state entities. In that role, he was responsible for international dispute management and for developing the company's international dispute resolution program. His position led him to arbitrating and mediating disputes across the globe, and in developing a particular expertise in investor-state dispute settlement. This in turn led Wolf dispute across the globe and in developing particular expertise in the ISISD. This in turn led Wolf to being trained as an arbitrator, where he achieved the FCIR designation, and as a mediator to being where he was trained by and he was certified by the CEDAR. Since retiring from Northrop, Wolf has, together with ICSID, the ECT, and the CEDAR, devoted his energy towards development of mediation in the context of ISDS. He has held board positions with several of the leading international ADR institutions and is on their training faculties. He is currently on the council of the AAA and the co-chair of its mediating committee, as well as the board member of CEDAR. Wolf is now an independent mediator and arbitrator with Arbitra Arbitrators and Mediators, with offices in London and Washington, DC, where he sits as an arbitrator, mediator, and dispute board member. He also advises governments and companies on implementing effective conflict management programs. Welcome, Wolf, and pleased to have you with us here today. Moving on to, last but not least, we have Martin Hauser, a certified and experienced commercial mediator offering online mediation and in-person mediation sessions. He has a legal background on intellectual property, IT, license, distribution, competition, complex industrial projects, and international business law. With over 30 years of experience in France as a business lawyer in commercial litigation, international arbitration and negotiations, Martin Hauser works exclusively as a mediator on resolutions of complex and emotional legal conflicts. He has been involved in investment mediations in telecommunications, oil and gas sectors as well. And he leads the national and international commercial mediation in French, English, and German. Martin Hause is also a member of the Munich and Paris bars. Martin holds a degree of master's in negotiation and mediation from European universities of Viadrona, Frankfurt Oder, Master of Comparative Jurisprudence from New York University, doctorate in law from the University of Munich, and law degrees from universities of Munich and Freiburg. So welcome to all our panelists here with us today. And to kick things off, Froka, can you tell us a bit about investor-state mediation? Why mediation and how does it work in real life?
Thank you, Amra, and thank you to the entire organizing team of the IIMC. I'm really delighted to be here and to support the first investment mediation mood in today's panel with friends and colleagues on investment mediation. So why mediation? From the ICSID perspective, I can start that by now, almost 4 years ago, in 2018, we proposed to our member states a set of mediation rules for a number of reasons. One is on the policy level, we observed that over the past decade, so by now about 15 years ago starting, states have adopted mediation as a process in investment treaties alongside the existing arbitration and conciliation route. And so we wanted to support that development with a set of rules, mediation rules, a framework to implement really these provisions. And then on the policy level, and I see you will discuss that later today, I think for me, maybe tomorrow, the Singapore Convention, the multilateral community working on a convention to support enforcement of mediated settlement. And the drafters, as I think you've also heard from our UNCITRAL colleague Judith earlier, did not mean to exclude investor-state disputes that are settled through mediation from the application of the convention. And Alejandro's work we already heard about. Also to mention on the policy level in 2016, the investment mediation guide adopted by the Energy Charter Conference, many of whom are also ICSID member states. And certainly in practice, the fact that 30 to 40% of investor-state arbitrations settle every year is a strong indicator that parties wish to settle those disputes, and we wanted to support those options. How does it work? Let me just quickly pull up a slide, a process overview, just to talk about the ICSID mediation, that you start off with a request for arbitration, that's a request for mediation that is filed, that either contains already an existing agreement to mediate, or if there is no agreement to mediate between the parties, the request can contain an offer that ICSID then would transmit to the other party, inviting that party to state whether it accepts or rejects that offer to mediate. Once you have that consent perfected, you have the registration of the request that is followed then by the appointment of either one or two mediators by party agreement. Following that is the first initial written statements by the parties, where the parties are asked to set out their views on the disputed issues and process. And that is then followed by what we call a first session, a first joint session, where the parties and the mediators develop a framework for the mediation that we call a protocol, on the basis of which the mediation will then be conducted. Termination of the mediation can obviously happen by a notification that the parties have reached a settlement, or that they mutually agree to terminate the mediation, or that the mediator comes to the conclusion that there is no likelihood of any settlement in the course of this mediation. So that's just a short overview from how the ICSID process works, and I hope that answers your question.
Of course, Rauka, but I must say you made that complex question so simple by just driving us through that procedure in bullet points, of course. Moving on to, I would like to just drive a question towards Alejandro. Energy Charter Secretariat model instruments on investment dispute management. It sets out policy options for domestic legal framework to support effective investment dispute management, including through negotiation and mediation. So what is the state of investment dispute in the energy sector, and how is it developing currently?
Thanks for the question. First of all, before I forget, congratulations for the great initiative, not only the conference, but in particular for the mood. I think it's very important efforts of what we are going to talk about, promoting and make sure that people understand what's mediation, how it works. And why is that? Well, it's clearly that when you talk about economic activities, in particular in those very sensitive areas or sectors like energy, you have a very highly regulated area. And that results, whether you want or not, in a frequent interaction with all types of authorities at all levels, between the company and the regional, local, state authority. And sometimes there is not good coordination. Sometimes those authorities are not very familiar with all the obligations, either in contracts, international agreements, even unilateral commitments they have. So they may enter into unintentionally, and they may enter into conflicts or frictions with the obligations already undertook with foreign investors. This is even more important in the case of the energy sector, which you have large, complex, very capital-intensive projects with very long lifespans, during which there are several changes probably of the government, the project personnel, and even the economic circumstances, as we have seen recently. Therefore, those initial conflicts or frictions may derive very easily into very problematic disputes that involve public policies. They attract a lot of interest from the media, the politics, and implicates important claims, substantial money, monetary damages, as well as risk of reputational damage of the country. That's why it's very important to try to prevent those disputes, or at least to know how you can try to solve them in an amicable way. If you look about the different cases we have, at least in the Energy Charter Treaty and in other agreements or contracts dealing with energy, you see that most of the breaches relate to the fair and equitable treatment, and that's by large the main breach found generally. And you then find some problems with discrimination, compliance with contractual obligations, and indirect expropriation. And this is more and more with renewal cases by the introduction of regulatory reform. We have seen that more and more is becoming quite relevant, invoking environmental issues, in particular climate change, Paris Agreement, as a way of defending of states for introducing some regulatory reforms. That's becoming more important. So important thing to take into account of the relevance of the investment mediation is not only what I just mentioned, but also the fact that you have in front not another company, but a state. And the dispute is not about just a commercial transaction, but is a measure taken by the state exercising the sovereign power. So you have some sort of different balance of power and what can be done during the whole process and the impact that one party can have during the process. But you also have to take into account that during the dispute, you may affect other parties that are not initially involved. You have other governmental agencies, or you have local communities, you have different non-disputing parties that can be affected in the process. And you also have the question on to make sure whether the state has or not authority or the possibility to mediate or to solve those particular disputes. So as you can see, there are several things in the nature of this type of disputes and that makes it even more interesting to consider investment mediation. It's not just a simple commercial dispute between different parties.
Yes, of course, Alejandro. Thanks for sharing that insight on this very niche area of energy sector. But in the context of building and making investor-state mediation mainstream, James, having experience as a trainer and being heavily involved a lot in investment mediation, what is crucial in terms of capacity building and what is really needed to advance this field based on your experience in this developing field of mediation?
So let me start also by adding my congratulations on the MOOC particularly, and maybe I'll start there actually, because one of the things that's needed is capacity building and awareness raising, not just amongst the lawyers and the mediators and the arbitrators. but also among students who will be the lawyers, mediators, and arbitrators of the future. So it's great to see that this moot is taking place, because that's a sign to me that it's the beginning of investor state mediation is really starting to take hold. So that's the first thing. And the general interest is clearly there. From there, the next thing you need systemic rule and process changes, because we're talking about a change away from mainly almost completely arbitration in investor state disputes to looking at mediation. And you see that happening already, right? Frauke has mentioned the exit rules, mediation rules, which are new. ECT has developed guidelines and protocols. UNCITRAL and their working group are looking at this also. IBA have mediation rules. So you see institutional and systemic rule change taking place as well. And next to that, the third area, you have institutions acting as catalysts. So the two institutions here, ICSID and ECT in the investment area, CEDA as a mediation organization, and others are all beginning to push this idea and support it. And that's important because it gives parties, and particularly state parties, I think, the sense of comfort that this is a credible process, and they know where to go. They know ECT, they know ICSID, they don't know CEDA. And so they have comfort that this is a serious process. You clearly then need a well-trained group of mediators who have experience in investment type disputes. And that's, I'm sure we'll talk about that. That's what CEDA and ECT and ICSID have been cooperating on for the last few years. And once you have that, and you have mediators and lawyers and trained and comfortable with the process, then obviously you need successful mediations, because nothing sells mediation like successful mediation. Once you do a mediation, it's really like a light bulb going on in your head. So I'm sure once that happens, more and more happen, then you'll get the snowball effect, and then it'll just keep developing and developing.
So thanks for driving us through that rundown of how crucial it is in this nature. Moving on, I would like to now hear some valuable insights from both Martin and Wolf. So Wolf, if you could share a perspective in comparison to other categories of mediation, such as commercial, family, and criminal mediation. How is investor state mediation different? And I would, of course, like to hear from Martin as well following this.
Okay, thank you very much, Amra. And again, thank you to the organizers for organizing this event. I think if people have the opportunity to look at some of the moot scenarios, I know some of us were involved in helping to draft those, you'll quickly see that this is very different from a typical commercial mediation. While it has commercial elements, of course, involved, there are real distinctions. And I think Alejandro has already alluded to some of those distinctions, because you don't simply have commercial parties with commercial interests that are trying to resolve a dispute with each other. There are many more elements involved in this type of dispute. And I think traditionally arbitration has been utilized because it's a forum in which a determination is made by a tribunal. And that seems to certainly have been what brought arbitration into favor in this particular area. Mediation, of course, is a very different skill set. A mediator helps to facilitate a resolution with the parties. The mediator doesn't make a determination at all. So it's very different than the arbitration process. But because of the different elements that are involved in this type of investor-state dispute, and Alejandro alluded to the political forum, of course, a state as a sovereign has a very different position than a commercial party. But as a result of that, there are elements that create a different type of environment for dispute resolution. So you've got a political spectrum that's involved. you've got a public spectrum and public interest that's involved in these types of disputes. States have budgets and have to balance the needs of the public and of course their commercial needs. So there are different considerations that come into play when determining how to resolve that kind of dispute. There are also, as Alejandro said, different stakeholders. They're not just the parties that are involved in the dispute, but within the state itself. The state organ is very different. I mean, you have different state officials that might be involved. You might have in a federal state, provincial governments that are involved. You have communities that are involved, community leaders that are involved. There may be NGOs that are involved. So there's a huge spectrum of potential stakeholders involved in these disputes as well. And as we talk about the process design for this kind of dispute, all of that has to be taken into consideration by the mediator or the mediators if it's a co-mediation situation, which you typically as a mediator in a commercial dispute would not have to take into account. And maybe my final point here is one around transparency. As we know, confidentiality is an important aspect of commercial mediation. But where a state is concerned, and there are public concerns involved as well, there has to be more transparency. And this is already being recognized in the arbitral world, but it also has to be recognized in the mediation forum. And so what is the balance there between transparency and confidentiality? And that's another important element or distinction from commercial mediation. Martin, I'm sure you may have some other points.
Okay, thank you, Wolf. Thank you, Amrei. Thank you for having me here. And it's really nice to see you again after virtual Paris, where we met at the ICC competition. It's really a pleasure. I totally agree with what Wolf said, obviously. However, I would take it a little bit from a different angle. You're asking us what the difference is between investor-state mediation to family and criminal mediation. Under this angle, I would say that commercial mediation, investor-state are pretty close because family and criminal is totally different. This is between private persons. It is about personal issues, whereas investor-state and commercial mediation is very often or mainly about economic issues. However, the big difference between commercial and investor-state is, of course, political influences. As Wolf said, confidentiality is treated and seen differently. Much more transparency questions than in commercial mediations. Commercial parties normally want this to be completely confidential. Investor-state, this can be seen differently. Another point which is also very tricky, it's already tricky in commercial mediation, is authority. It's always difficult for me to get the right people around the table. This is one of the major issues to make a mediation, a commercial mediation, a success. Now you imagine this having a state on the other side of the negotiation table. Who is representing the state? Does this person have power of attorney? In which way a settlement will be authorized or implemented? The rules have different sayings on that. This is a major issue. It's a very important issue in both, but I would also say it distinguishes commercial mediation and investor-state mediation. And what I would say is commercial mediation is not necessarily intercultural. You can have a commercial mediation within the country, can be also intercultural, but investor-state is, I would say, by definition, intercultural because it's a foreign investor who invested in a state. So there are different aspects, but when you come from the question, what is the difference between investor-state, commercial, family, and criminal, I would nevertheless say they are both close, investor-state and commercial, and has nothing to do with family and criminal. Thank you.
Thanks for sharing your insights from both Wolf's and Martin's perspective from different angles. Of course, that's a very broad area. And once again, moving on to a question directed to Frauke, how have the existing rules, such as those by the IBA and ICSID, affected investor-state dispute settlement sphere?
Thanks, Amra. And when I hear that question, just the question by itself makes me happy because we're talking about how have existing rules shaped the ISDS landscape. And, you know, a few years back, we didn't have any rules, and it was sort of like a construction, a theoretical construction. And now we're actually shaping the landscape. And I think that is hugely satisfying just for the question. So how have they shaped the landscape? I think putting it into context, we have the discussion about investor-state dispute settlement reform has now been ongoing since 2016, 15, 16 is when it turned into the more of the public discussion. In 2018, we proposed our amendments and the reform from the ICSID perspective. And of course, you've heard already from Judith about the UNCITRAL Working Group 3 for an investor-state dispute settlement reform. So you have that as a universe, let's say, about reform. And within that, you know, Anna Joubin-Brett, the secretary at UNCITRAL, is actually one of the major players, or was and still is, one of the major players of the IBA rules. So we have a continuity of players involved in that. And within the ICSID proposals of mediation rules, the consultations that we had with our 156 member states, I think what the rules have done is they have put mediation squarely on the table, helped to implement what we already saw in the treaties, but also served as an educational tool. How does it work? What is the framework? What is the process? What are the process steps? How is it different in mediator appointment from my arbitration tribunal? How does the process work once the mediation is underway? So in that sense, I think the mediation rules have really helped to elevate the discussion to a different level. And then to take it a step further, they also serve to take the policy to a different level, that states can include in their treaties, parties can include in their contracts references to these rules, much like they have done in the past for arbitration frameworks, ICSID, ICC, SEC, for example. Now you can create policy instruments with references to the mediation rules. So, and you see the discussion, UNCITRAL has a paper, a background paper on mediation and model clauses, and there it's a whole package that I think we are at a different level of discussion than we were a few years ago.
Of course, that shows so much growth in the past few years that we've grown in, and the excitement of all of us interested in this field. Moving on to another question to Alejandro. In June 2016, the Energy Charter Conference adopted a guide on investment mediation. And in what ways has the 2016 guide contributed to the promotion of mediation?
Thanks. The original idea or the main aim or objective of the guide was to have, I would say, a first explanatory document that could be used as a reference, but by both governments and companies to better understand what actually is investment mediation and how it works. Because that's the only way they could actually sit down and consider whether investment mediation will work for them or not. First, you need to know what you're talking about. So it mainly tried to provide them with simple explanations on what is actually mediation, how the process will develop, and things that were relevant at that point in time for governments, such as, you know, how you prepare your team, what kind of preparations you need in the sense of documents or people joining the team, which were the actual mediation rules they could refer to, or even institutions, because it was not very clear at that point in time. And then how to select a mediator, or even assess whether mediation was an interesting tool for that particular dispute. And I think to some extent, the aim or the objective was achieved, since at least it helped to trigger quite a lot of discussions afterwards. It is, I say, at least for the members of our organization, it raised awareness about what is investment mediation, how can be used, when can be used, and it's something that actually trigger more questions and more discussion. And I think as such, it has been quite helpful. And it has also, I would say, served as a source, initial source of reference for further later initiatives. So I think it was the first attempt, at least, to try to explain what it is, how it works, and to facilitate further discussion.
I must say that this is, of course, a comprehensive guide to any new starter in this particular field, with all basic guidelines from scratch. Yes, of course. Moving on to a question directed to James. The CEDAR, ECT, and ICSID conducts joint trainings on investor state capacity building workshops and trainings for mediators and government officials. Similarly, what specific activities can change these leading organizations to conduct and promote capacity building on individual and larger scale basis?
Well, you mentioned training of mediators, but clearly training of other professionals who are going to be involved is important as well. So the training of state officials is really important for them to understand mediation and how it works, and then for them to consider how to bring it into the state structures. So there's two pieces of work. It's basic understanding, but then more detailed work with states on how they are going to be able to, for example, address the issue that Martin raised around authority. If they're going to mediate, how is the state official who's going to be at the mediation be able to have authority to reach an agreement? So there is work to be done with the states. Well, on the investor side, I mean, investors tend to be a little bit more aware of them because they may have come across mediation in a commercial dispute context, but still work needs to be done with the commercial parties and investors. Work also continues with institutions as well, so ongoing conversations with organizations like ICSID, ECT, ADR organizations such as mine, how we can help and work together. And I have to say there's been quite a lot of really good collaboration across the globe on these areas. Also, UNCITRAL is another example. Judith, I know, is on the line. So those types of initiatives are important because it gets us all talking with one voice. And as Alejandro mentioned, it also gets us to work out some of these issues. Actually, how will we resolve this issue? Because it is emerging and there are issues which need to be considered and thought through. And the rules development that Frauke mentioned also plays a part in that because it helps us think at very specific levels, how do we deal with issues which are particular to an investor-state mediation. And the final area, I think, is just winning hearts and minds. You know, a lot of people are convinced, but there are still some people out there in what I'll call it the traditional ISDS space who perhaps are not yet convinced that mediation can work in this space. And it will take some time, but I'm sure that eventually we will show that our investor-state mediation can and will work.
Thanks for sharing your insight on that. And it shows how imperative these initiatives are. And of course, they can only be achieved if they're done collectively with all rules and institutions involved. And on that note, directing a question towards Wolf and Martin, of course, what are like the unique features, like in terms of the obstacles and challenges, if any, a mediator or a counsel may encounter during an investor-state mediation?
Well, maybe if Martin doesn't mind, I'll just kick this off. I think it goes back somewhat to what I was saying before about how arbitration developed in the ISDS world. I mean, under ICSID, there were also conciliation rules that people could have used, but the conciliation rules haven't been utilized very often over the life of those rules. And arbitration became the norm. And that's largely, I think, because state officials in particular wanted to avoid any kind of responsibility for making any kind of determination in this type of dispute. And I think that is still one of the obstacles that we have to deal with in convincing states to utilize IS mediation, and that is for state officials in particular to feel that they have the authority to even utilize mediation as a tool for resolution. And this goes back to the political context. A lot of these issues, let's take the energy sector that Alejandro was talking about, become political issues within the state. Let's say that there is now an effort by the state to move from carbon energy to renewable energy, and it has many concessions with oil companies with respect to oil production, and so moving from that will clearly create a dispute with the oil producers. So within the state itself, that could be a very highly emotive situation. The populace of the state might very well want to move to a sustainable energy, and yet there are legal commitments that the state has to these producers. So how does that play out then in a mediation context? So you have to try to envision that, and for the state official then to try to be involved in resolving this in an amicable fashion. It's much easier to turn that over to a tribunal, let the tribunal decide that. I don't want to be involved in it. So I think that's a key area or an obstacle that has to be overcome. And even if state officials are willing to become involved in a mediation, there's always the concern that they have, and we've seen this even in Western European countries, where a resolution or a settlement is found with somebody, which later then is questioned, and the state official might themselves face sanctions as a result of having been involved in that settlement. So I think those are obstacles which clearly have to be overcome if IS mediation is to take off. Martin?
Thank you. To both, if I understood well, the question is, and I would like to take that a bit further, is what are the obstacles and challenges counsel and mediator face during a mediation? And in that sense, I would like to take it a little bit further. I've seen one case, you will say this is maybe not unique, but I've seen investor-state mediation, a party which didn't show up. What do you do as a mediator? What do you do as other party counsel? There were three parties, one state agency and two other foreign companies, and one wouldn't participate. What are you doing? This happens also in commercial mediations, but it's particularly difficult, I would say, in investor-state mediation. Then obstacle is also obviously the whole political environment, which from a mediator's point of view, you have to understand somehow. But how do you do this? Not easy. And then you have what you also have in commercial mediation, but with huge companies, you always have the problem that you do not know whether the person who has the power of attorney, who has the authority, actually is not afraid about pressure coming from the company. How could you accept anything like this? And now in an investor-state environment, the political pressure, what is going to happen to my career? What happens if the political regime changes in the country, etc.? This is something you have to face as mediator and counsel, and always be aware that there might be something like this, especially when a mediation doesn't move on. This is what we call the avoidance of accountability. And now the challenge, what is the challenge? The challenge is, and I think it's very well laid out in the background paper from ICSID, is the understanding of actually the environment and the domestic policies, the legal, the social, the cultural, all these aspects. This you have to understand. You should understand this opposing counsel, and even more as mediator. But again, it's easy to say that, it's very difficult to do it. Thank you, Amar.
It's of course, great to hear, based on even your personal experience, how we or anyone who's interested in one day pioneering this field, how they could encounter and face such circumstances in this sphere. So, Frauke, from what I've heard, there are like multiple treaties that are now increasingly promoting mediation as an ADR mechanism. Can you tell us a bit about any recent policy developments in these treaties?
Yeah, sure, I can do that. So we published in July a background paper on mediation provisions in treaties. I put the link in the chat. Let me see that I can send it to everybody. I cannot, but if someone of the panelists can maybe send that over, that would be great. And that is what I will briefly, in just a couple of minutes, walk you through. We analyzed about 1,000 treaties and came to categorize them in sort of 5 different styles of how the treaties dealt with mediation. Traditionally, we have treaties that have an amicable settlement period of a certain duration prior to the institution of arbitration proceedings, and they require negotiations or consultations, but no specific mentioning of mediation. Then you have a set of treaties that identify mediation and expressly refer to mediation in the context of the amicable settlement process as one of the processes parties can resort to, but obviously don't have to. Now we escalated a step further. Then there are clauses in investment treaties and model investment treaties that affirmatively encourage the use of mediation during the consultation period. And how do they do it? They give policy directions. The state involved should give positive, favorable consideration to mediation if a request from an investor is received, or certain milestones need to be reached in the context of the mediation. For example, 6 months need to be attempted to negotiate through mediation. And then the 4th category, now we have, no mentioning positive, favorable consideration. And the next step is the mandatory mediation. Mandatory mediation for parties to resort to mediation as a precondition before instituting arbitration proceedings. And here that is the Costa Rica United Arab Emirates bilateral investment treaty to mention, but also the COMESA. So interesting there is that you have different regions of the world coming to that policy development. And we will have on January 12th, so 2 days, at least in DC, it will be January 12th, at 9 o'clock Eastern Standard Time, we'll have a webinar where we feature policymakers from Costa Rica explaining the background, and that is the segue to the last set of treaties, and here mentioning the EU treaties, the EU FTAs, envision mediation as being available throughout the life of the investment dispute. So it is not just limited to the amicable settlement period, but throughout dispute settlement procedures, parties can resort to mediation, including in parallel to arbitration. Suspend the arbitration and mediate, or mediate only parts of the dispute, that is possible. So that's a short overview of our long research.
Of course, and that's exactly what I was to say, because you made it very concise in a very simple form for all of us to understand. So Alejandro, just as Frauke has mentioned earlier about the evolution of the international framework and the rules to facilitate investment mediation, would that be enough, or is anything else needed to be addressed at a domestic level?
Yeah, so in 2017, I would like to refer to some survey we conducted just after the current investment mediation. And we tried to identify something that has been just discussed a couple of questions before, which were the main obstacles and concerns regarding the use of investment mediation. We see that it's more and more referred to in investment agreements. So why are not so much used by the governments? And the main answers, the main concerns was the lack of a clear domestic legal framework. So still it's possible to go to mediation, of course, but there are some concerns there, some drawbacks. And the main ones are, as has been mentioned already here, ambiguous authority to settle or even to enter into discussions, fear of possible allegations of corruption. So those government officials who may propose or may conduct mediation may be under fear that there will be later potential liability complaints of the result of that mediation, and the lack of funding of the whole process. So in short, the answer is yes, it's very important to have that clearly referred and expressed in investment agreements, but it's still also as important to have a clear domestic framework that will clearly provide the legal basis for negotiation and mediation, and will clearly identify who has the authority to settle, or which is the process to get the final okay. And also provide additional practical issues like how do you get the money for entering into the process. And because of that, in 2018, the Secretariat again, and this is very important, in cooperation with other institutions like the World Bank, ICSID, ANSI-TRAL, and government officials, we brainstormed and we thought about how we can provide a model instrument, a model guide that government officials can take into account to develop their own domestic framework. So that's why this model instrument came to light. We tried to introduce there very practical issues, different policy options that the states could consider based on their own circumstances, their own legal backgrounds. But we really think, and we have seen in further discussions and meetings with government officials, with companies, that it's very important to also have this domestic framework, where at least you identify who is the main responsible body, who coordinates, who takes the final decision, who has that authority to negotiate, and also to come with important issues about how to deal with the confidentiality, transparency requirements, and how to have a final decision on the potential settlement, on whether in that particular case, actually mediation is the best or not the best. So yes, the international framework is important, but also the domestic framework.
That shows like how significant it is for all of us getting the foundation strong within our own legal system. And having discussed about the challenges and obstacles faced, I think it's quite imperative that we explore the most common misunderstandings about investment mediation. So James, could you just share with us what are the likely reasons for them and what is the reality to it?
Yeah, I mean, many of them have been mentioned, so I'm not going to mention them again. We've talked about the issue around authority, transparency, those sort of things, which I think people understand well enough. But there's some others which are often used. The first, and if I had a pound or a dollar for every time I've heard this around the world on different mediation initiatives, is the yes, but reason. Yes, but it can't work in investment state mediation because we're special. The exceptionalism idea. There's nothing exceptional about investor state disputes as it relates to settling them. In fact, I think ICSID statistics show that most investor state disputes actually do settle. So actually the comparison isn't between mediation and arbitration, it's actually between mediation and negotiated settlement. So there's no reason that investor state disputes can not be settled via negotiated settlement and the negotiations, and they are all the time. So I think that's one thing to be really clear about, because that's often used, oh, it's too complex, for example, you can't mediate these types of disputes. Of course, complex commercial cases are mediated all the time, and quite successfully. And so again, the idea that a complex case cannot be mediated is a misunderstanding and not consistent with reality and years of experience. Now, the other one, which is often used in this space is, well, you can't mediate with state parties, with governments. And that's just patently not true. Because in the commercial space, and Martina mentioned it earlier, I think investor-state mediation and commercial mediation are very similar, or subsets of one another. You know, we routinely mediate with government officials in areas where you wouldn't have thought it possible. A good example is in the UK, where tax disputes are mediated by tax officials, and tax officials come up on behalf of the Revenue Service and settle cases. So again, state parties can mediate and routinely do mediate. Of course, there are issues, as we've discussed, about authority, but those can be resolved. And one final one is, well, you know, if it doesn't settle, it's, you know, it isn't all a waste of time, because if it doesn't settle, you know, then we have to carry on to arbitration. The first thing to say is that 70% or more of cases settle on the day or shortly thereafter. So you have a very good chance of settling the case. And even if you don't settle it, you've probably narrowed the issues in dispute so that the subsequent proceedings are going to be more constrained and more focused. So those are some of the misunderstandings, but I could go on, but I am conscious of time.
Thanks, James, for sharing insight on that topic. And now, having addressed these aspects, I think it's crucial that we divulge into what the necessary skills are to create, you know, a cadre of competent mediators with the skill set that can effectively deal with the growing demand in mediation, in investor-state mediation, as well as how we can overcome these challenges mentioned previously. So over to Wolf or Martin, you can take over.
Well, yeah, thanks. Maybe I'll just kick this off. And this is actually a topic that ICSID and ECT and CEDAR, IMI have actually been dealing with for some time. In fact, it's interesting, and Frauke was involved in the drafting of the IBA rules some 10 years ago or so, the IBA investor state mediation rules. There was already an attempt there. If you turn to those, there's a list of criteria for mediators in investor state disputes. And it's interesting to look at that today, perhaps in the context of how this whole area has evolved. IMI actually has a criteria that it has drafted as well. And in the training that the institutions have been undertaking, they've very much drawn on that criteria as well in the training. I guess just simply put, you clearly have to have basic mediation skills. So people who have undertaken mediation training, who have practiced mediation, perhaps in the context of commercial, but also in other contexts, that is clearly useful. But as we've already heard from everybody here today, there is a different context with respect to investor-state disputes. And so part of the training and part of the background of mediators who practice in this area will be to have an understanding of the investor-state dispute system, ISDS. I mean, you do have to have a basic understanding for it so that you understand what the context is within which you're mediating, as you would in any other type of mediation. You have to understand the legal context in which you are mediating. And so that is another element, I think, that is important. We've already alluded to, and Martin, I think, put it quite well, that there's a cross-cultural element to this type of mediation in every case, because there is a foreign investor that is investing in a host country. And so there is going to be a cross-cultural element. And we've realized, even in a commercial mediation training, that the cultural element and the cross-cultural element, even in domestic mediations, there is an element of that and an understanding for it is something that clearly is going to be very useful. We've also talked about the process design for this kind of mediation, and that there may be many other stakeholders involved in the dispute, which you wouldn't typically have in a commercial type of mediation. And so that process design is extremely important in understanding how to help the parties to design the process for the actual mediation before you even get into a discussion of the mediation is something that is very useful for mediators to learn in this context. And so that's another element I think that has to be added to the training. So maybe Martin, from your perspective as a mediator, how would you see it?
Thanks, Wolf and Amra. I would just like to add, you spoke about the IBA rules and the IMI criteria. I would like to go also back to the background paper ICSID published just last year. There is a new criteria, which is, I touched on that already, which is the understanding of context and framework of investor-state, I'm reading this, investor-state disputes, including economic, legal, social, and cultural considerations. Now, getting back to the question about the skills, I agree with everything you said, Wolf, but I will make it very short. I would say a mediator should be experienced. It must be a good mediator. You're going to say to me, well, what's a good mediator? A good mediator is somebody who has listening skills, who is empathetic, can listen to people, tries to understand what's ongoing. Major here in this field is intercultural competence. And he has to have, and we totally agree, some kind of experience in conflict resolution involving states. That can be international arbitration involving states. That could be peace mediation. I did a bit of peace mediation at Viadrina University, most fascinating. This makes you a little bit familiar with dealing with states because it's not easy. I cannot say to the students, this is the list, that's what you're going to do. Because how do you meet this criteria about, let me take it again, understanding of the context and framework of investor-state disputes, economic, legal, social, and cultural. That's a lot. So I think you better start off with being a good commercial mediator, doing peace or international arbitration involving states, and slowly by slowly, you're moving on. That would be my advice. Thank you.
Thanks for sharing those crucial or most highlighting aspects of skill set that is required from that perspective. And directing back to Frauke, how can we determine whether mediation is the right ADR mechanism to resolve investor-state dispute? When can this be used? And what are like the most common benefits over mediation compared to other mechanisms like arbitration? And it seems like we must have also divulged this area again previously, but of course, to hear your perspective on this, Frauke.
Thanks, Amra. I'll try to keep it short. There are a couple of factors that parties could consider. I think the importance here is to start out with what is the right process to resolve a dispute is a very subjective assessment, and it depends on what the parties to the dispute desire. And obviously mediation as a facilitated negotiation, the starting point is, do you have any willingness to enter into negotiation? And if that answer is yes, then you can explore a couple of other factors, and that is one, to look at the dispute comprehensively. Look at, are there different aspects of the disputes? Is it is it only one thing, or are there different subsets of the dispute that could be negotiated while others, the parties, desire for arbitration? The point here is that there is not everything here or everything there. But once you as a disputing party look at the dispute in more detail, you may come to the conclusion that parts of the dispute are suitable for negotiation and mediation, while others you may not. So that leads then to a stakeholder analysis. So looking at the parties that are involved, and Alejandro had mentioned that early on, that the parties who are involved in the dispute may not necessarily be the same as the entities that are needed to find a resolution, especially a negotiated resolution. You may need to go to a different ministry up in the line on the chain of command, whereas the original dispute originated on a local level. Then the question whether parties want to remain in control of the process. What is it that the parties want from the process? A mediator, Wolf mentioned it earlier, doesn't have power, for example, to grant interim relief. If that is your goal as a disputing party, mediation will not be the process for you. And then, of course, what we've been talking about all along is the control over the outcome. Do you, as a disputing party, want to shape the outcome? What is it that should come out, and how should that look? And take that responsibility. We talked, Martin mentioned it earlier on, that is part of the negotiated solution, whereas in arbitration, if we contrast it, the tribunal is the one who will make the binding resolution on the parties. And interestingly here in our discussion, as I listened to it, we often come back to, oh, these investor-state disputes, can they be mediated? And I just refer back to the statistics that we have 30 to 40% of arbitrations that settle. So somehow in those instances, this is no longer an issue. So we are not in a completely new area, but we have seen that this is all possible. And then looking at financial resources for the disputing parties, how many funds, how much financial resources are available for the dispute settlement process, and assessing their arbitration costs and mediation costs, obviously much lower. And the desired time frame of a resolution. What would parties like? How long should it last? How fast do they wish the process to move on? And as James mentioned, even a mediation that doesn't result in a full settlement or a no settlement at all, from the investors that we have talked to, certainly the feedback is that during the mediation, you learn a lot about your case and about what it is that you want out of this. And that might be helpful no matter what dispute resolution process you pursue. And another portion of your question related to when mediation can be used. And by now, you know, I like little charts and timelines to make complicated aspects easy to understand and follow. And here on the slide that you can see, we have on the one hand, on the top, we have sort of an investment dispute chronology. How does the dispute start? You know, investment disputes don't happen overnight. They usually simmer for quite a bit until then they either end up in arbitration, or you have on the timeline a point where the investor may decide to cancel the investment. And statistics from the World Bank indicate that only about 6 or 7% of investment disputes actually end up in arbitration. That means 93% of disputes are either not resolved or are resolved in a way that arbitration practitioners don't know about. And those are the disputes that could particularly benefit from mediation. And so when we go back to the basics that mediation is facilitated negotiation, mediation is available whenever negotiation is available. And that can be even at the very start of an investment, to come to a conclusion of an investment concession, of a concession agreement. And then throughout the lifetime of operations, investment operations, and then certainly in this amicable settlement period, but also alongside arbitration. And mediators will tell you it's not unusual to have mediations even after an award has been rendered on implementation or other solutions. So those are my thoughts on when it could be used and what are sort of criteria to think about.
Thanks, Roka, for once again making complex matters easy to understand and explain, of course, and sharing with us such valuable surveys. So moving on, in terms of a company, for instance, could companies also do something to facilitate the use of investment mediation? I'd like to hear your thoughts, Alejandro, from this perspective.
Yeah, thanks. I think it's important to start by saying something that is clear to everyone. When you have a dispute, normally you have at least two parties. You cannot solve a dispute if both are not trying to come to the table. In case of investment disputes, of course, these get more complex. We mentioned before, there may be more than two parties. So you may need to try to get more than two. But at least let's have the company and the government in the same line sitting at the table. That means both need to know what is investment mediation, how it works, and to have all the knowledge behind. I mentioned before the complexity of these cases because having the state on the other side and how the state has different entities and they are not always aware of all the obligations they have and they're not always coordinated. But the same can go sometimes with companies. You can have a small company, you can have a big multinational that is not always aware what is the project company doing or what is the different issues or personal issues going on, or that also they are used to arbitration, but they're not so much about disputes with the states. So this is something that is starting to change now. And the same as we were proposing governments to have their domestic framework, it's also important to know that companies are also moving into that line and they are having more and more internal guides on how to use alternative dispute resolution. But it's important they also work on having some internal frameworks and policies on how to manage also those investment disputes, how to incorporate into account more investment mediation. So not to just resort or directly resort to international arbitration in case there is a dispute with the state. Reality shows also in some surveys that most companies, at least the big ones, they are more interested in solving disputes than to try to go directly to arbitration. But there is sometimes difficulties in trying to find out who will sit down on the table, how to involve the government. So it's useful for those companies to try to have those also internal policies on how to facilitate this culture of investment mediation on both sides.
All right,
And
thanks
maybe,
for sharing.
sorry, just to reinforce that, Amra, I mean, given that I
course.
had 25 years experience as an international company lawyer, that's precisely what we did. I mean, we had an ADR policy and procedure and training for the people that were actually involved in negotiating these contracts, but also then in the program itself, the people that were responsible for delivering the project so that they understood how to utilize techniques that would help to manage any issues that arose so that they didn't even become disputes. So I think that's a very important point that Alejandro makes with having an ADR policy and procedure internally.
Really appreciate your contribution as well, Wolf, on this topic. Moving on, as we have already heard in terms of a narrowed perspective in a company, but what are like the effective ways that we could address the misconceptions amongst different stakeholders and their different groups? So James, your perspective in this thought.
Yeah, I'll keep this relatively brief because I think we've canvassed quite a lot of them already.
Yeah.
I mean, you heard Alejandro and Frauke talking about it. You do it through training, through capacity building, through systemic changes, either at the states or, as Wolf was saying, within companies themselves. There's only one area which we haven't talked about, which I would add is we haven't talked about the lawyers involved in advising their clients, either the state party or the investor party. And we CEDA's have got a law firm advisory council for investor-state disputes. And it's quite interesting talking to them about the issues that they see with their clients and how they have to quite often work with their clients to address some of these misconceptions. So CEDA at the moment is working on a guide for counsel that they can use to work with their clients will give to their clients. So watch this space on the CEDA website for that, which will be published eventually. But the lawyers also need the tools to have the answers ready to when their clients ask them some of these issues.
All right. So moving on, in terms of how much one must train to be an investor state mediator or counsel, we would like to hear from both of you based on your expertise. Martin, we would like to hear yours first, and of course, hear from Wolf as well.
Let's make it short. Time is running, and we touched a little bit already on the subject. Again, I would say gain experience as a counsel or mediator in commercial mediations. Start with that, then move into trans-border international settings. Try at the same time somehow to get acquainted with states in conflict resolution. There are two possibilities I see, maybe there are others, which is international arbitration or peace mediation. Peace mediation, again, can be studied and can be practiced. Practice is a bit more rare, but you can study it. And we are also speaking to students here. And then you have a very fine panel of teachers here, because I saw that on the 19th, there is a investment mediator training. There are Frauke, Alejandro, James, and Wolf, who understood that even the fees can be negotiated. You see, negotiation goes very far. And last not least, there's also your wonderful initiative of the Mood Investor State Mediation Competition. This is also a very good opportunity to practice, exercise, get experience, etc. I don't see anything more at the moment. Wolf, would you?
Yeah, no, I agree completely, Martin. I think you've covered it. I would just say that universities, I think, play an important role in this. And just as we're seeing here, the universities involved in this moot all understand that this is a developing area of the law for investor state dispute resolution. And encouraging students at an early stage. And we see this with mediation, this commercial mediation as well, getting students involved at an early stage. So it just becomes part of the natural process. And I think that's part of getting this into the mainstream, that people just think of it as part of the process of dispute resolution, because both states and companies at the end of the day do want to resolve these issues, because there's time and cost elements that are involved in bringing this through to a final arbitration determination, and everybody's better off. And I think as Frauke said, keeping control of the dispute yourself rather than turning that determination over to a tribunal typically brings much better results. So yes, thank you.
Thanks for sharing your thoughts as well on this particular question, Wolf. And moving on, considering the time constraints we have at hand, like initiated earlier, we would just open the floor to questions from audience, and I would certainly have them directed to me. So I would just directly ask them from the panelists. So with that, what will the trend be for the globalization and international investment in the post-COVID-19 world, and its impact on the investor-state dispute settlement? Of course, this is a very crucial topic that is of high relevance with what we're facing currently. So anyone would like to, share your thoughts on this based on your experience in the past couple of years? Open the floor to all of you. Yes, of course, Martin, you just may begin.
I would say I can speak from an institution point of view, but from the practicability, I would say the minute 2 years ago COVID started, mediation went online. It was easy to do. It was much easier than for arbitration, because you have to hear witnesses, you have to respect all kind of rules, very complicated. It's feasible, but complicated. Mediation is a very flexible process. So it was easy to adapt. All you had to do as a mediator actually is to learn how to use the video conferencing systems like you do, the Zoom, and you go online. And this is again, and still what we do. International commercial mediation is online. around the globe, actually. And I think that is what's going to happen with investor-state mediation as well. I don't see how the people can meet, and I don't see a big difference to commercial mediation. That's what I wanted to add. And what I wanted to add is I think this is here to last, even after the COVID, and that was your question. This is here to last. I think times where I had, for example, Indian parties and US American parties meeting in Geneva and me sitting in a glamorous hotel, I think this is finished. Meeting attorneys at the evening at the bar and have a chat about this and that, that's finished. It's all going to be online also after COVID. That's my point of view as a mediator.
Yes,
And maybe if I could just add to that, because that I think also fits in with what Martin said. But you know, I think I was involved with some of the peripheral discussions around COP26 in Glasgow late last year. And I think climate transition, so the energy transition, is going to create huge issues for states and for investors that the ISDS system that we currently have simply will not be able to cope with. And I think just going back to amicable resolution of disputes, mediation just is a natural tool for these parties to utilize, particularly as there's a broader public concern that's involved and other stakeholders that have to be brought into the discussion, which you simply can't do in an arbitration. So I think by the nature of the climate issue that we're all facing, mediation is going to start to play a much larger role in these types of disputes.
Thanks, Bo, for sharing your insight as well on this very current topic. And I would just like to direct another question we have. What does the future scope look like for investor-state dispute resolution mechanism in an international paradigm? Anyone just could share, feel free to share your thoughts. Frauke, Alejandro, James, anyone, Martin?
Sure, I can start. I think we are living the future as we speak with all the reform discussions. I think the future is already underway in looking at new ways of doing it. The pandemic, as Martin and Wolf and James is nodding, James has a podcast on this, I think, as well, on online dispute resolution technology, supporting parties to engaging in a different way than traditionally, and on a different cost level and a different speed level. You can, you now have access to government officials with authority much easier than you had in the past. Get a minister to travel for 3 days. That's much more difficult than to find a 3-hour window to log on. And so I think that is one thing we see in ICSID. The good news is that in 10 days or towards the end of the month, we're going to put the mediation rules and the whole ICSID amendment package for a vote for the member states until the end of March by correspondence. So that will be a big development. Hopefully they will be adopted later this year. UNCITRAL has already the discussions continuing on investor-state dispute settlement reform. And I know Alejandro is busy in renegotiation rounds as well. So I think the future will show a lot of movement and much interest in amicable dispute resolution in the investment context.
Yeah, I will agree with all has been said, and it's important to consider that, of course, it's not about invest mediation being the last arrival and moving away arbitration to this core, not a small room or something like that. So arbitration will remain there. Invest mediation will still be there, but more used. And the question is, the more people have the knowledge about both, will be able to understand for which particular dispute one will fit better than the other one, or which part of the dispute, which is another important thing, one of them can be helpful. And so they can interact each other, as Frauke mentioned before. You may start with one and continue with the arbitration, or start arbitration with mediation. And this will be even more helpful, as mentioned by other panelists, using this online methodology that we have been used now for negotiations. And I think there are going to be additional helpful guidelines based on the practice and experience during this year. So how to conduct those online discussions and how to take into account all these new rules that will be appearing.
I'll just add one comment. I mean, I think one of the interesting things, having been around mediation for many years, is that mediation is counter-cyclical. So when society or when the economies go through stress, people don't want to fight. They don't have the energy to. They're dealing with crises, right? And we have been in the middle of a 2-year crisis, and we've still got a number of years to go until we're out of it. So collaborative processes, sitting down and trying to sort something out and renegotiate a contract which no longer works because it was negotiated pre-pandemic, that is going to be really key as we begin to emerge into this post-pandemic world. So I suspect all this work we've talked about that's laid the groundwork for investor-state mediation will now really take off in terms of actual mediations because the worldwide economy needs it.
Thanks for sharing all your perspectives on that topic. And I must say, that's all the time we have in our hands, but I'm sure most of us as participants and myself are really intrigued by this very pragmatic discussions we've had on this emerging topic, and especially with your contributions based on your valuable experience. I'm sure most of us could take a step ahead in terms of the ISM mediation ahead. That would, of course, give them a perfect guide. And I'm sure most of them have taken their own notes that could be of use. So concluding, I would like to take a moment to appreciate all of our speakers here with us today for investing your valuable times and coming from various different time zones. So, and if, of course, the panelists would like to carry on with a chat with your colleagues here, we could move all of us, including myself, to like a breakout room. And of course, this, I'm sure many of us, if we are able to disclose, and others also connect with each one of you on LinkedIn, like myself, like how I've done with many of you, and I've known for quite long. So thanks, and over to Sadia from the organizing committee.
Thank you, Amra, for that fantastic job, and I wholeheartedly agree. I'd like to extend that gratitude to a wonderful panel, Frauke, James, Alejandro, Martin, and Wolf. Like James and Martin kindly pointed out during the panel, given that ISM and ISDS is very rapidly developing yet still niche area of dispute resolution, a large part of the purpose behind this competition, IIMC, is to raise awareness about ISM and ISDS and also provide opportunities and resources like the IAM qualification, criteria, and assessments that I believe Ivana shared on the chat to students as well as existing mediators, so that we can add to this pool of professionals like our excellent panelists. And a main method we do this by is sharing a learning opportunity like today, especially in the drastically different world we live in alongside phenomena like technology, COVID, and climate change, like James and Wolf mentioned. So I am confident that today's valuable takeaways will assist our participants not just in their rounds, but also in their future careers as mediators and advocates. And once again, I thank everyone deeply for helping us take this important step. With that, I will invite my panelists and the moderator to join the breakout room. And if any of the participants would like to stay back for a chat with us, feel free to do so. Thank you and have a lovely rest of the day.